Okay, here we go. Good afternoon, everyone. Welcome to our program for 2017. I'm Bob Clifford, and as the current chair of the American Bar Association Fund for Justice and Education, I am now and have always been committed to the quality of the practice of law, both nationally and in this state in particular, and as well as to promote civility and goodwill among lawyers. And I hope this is a timely program that helps advance that notion. The ethics of social media outside and in the courtroom. And it's another step in that direction of civility and greater learning for us all. And certainly it couldn't be more timely today than ever. For the next 2 hours, our esteemed panel will take us through hypotheticals, analysis, and study that will provide you with practical advice about how to better handle the issues around social media that are just now evolving and being crystallized with rulings in our courtrooms. We have over 4,500 lawyers who are not only here today at the small group at DePaul University, but also online, and that are registered for this program. It's a record for our 10 years of doing that, and thank you for your support, and that confirms my view that I think we're doing the right thing and people are interested. So I certainly welcome and I'm thankful for that support. The folks on the internet will be able to, there are people that are staffed here who will be able to take your questions, and we will try to ask as many of them as we can. Let me provide a brief summary to you of our panelists. Their full bios are in the materials. If you'd like to get the entire info and bio on one of these good folks who are here today. First, let me introduce you to the Honorable Lynn Egan of the Circuit Court of Cook County, who has been there for over 2 decades and is kindly devoting her time to this program today. She has spoken on this subject throughout her career, but also in particular her own acclaimed CLE series that she spearheads, and she's extremely familiar with these issues and is willing to present to us today as a member of the court and as she has served on several Supreme Court committees. Also, John Barquette, a graduate of Yale Law School and an adjunct professor at the University of Miami Law School. He joins us from the firm of Shook, Hardy & Bacon in Florida. John has extensively studied the issue of social media in the law and has been a frequent speaker on the subject. You will find his lengthy and up-to-date paper as part of the materials that he is debuting today as a contribution to this program and to the body of work, some of the best work on this subject matter. You have it here, and it's also posted on the website. Mark Palmer also joins us as the professional counsel of the Illinois Supreme Court Commission on Professionalism. He traveled here from his Springfield office, where he is an adjunct professor, also an adjunct professor at the University of Illinois College of Law. So thank you all for being here. I'll serve, as I have in the past, as a moderator today. Let's begin shortly. And to learn more, please explore the various materials and handouts that you have received electronically and here in the room. The seminar is being taped. Will be a 2-hour program, and the materials are available for viewing on the website, cliffordlaw.com, but not for credit. The only credit is for those who are formally registered today. So let me begin by reading to you the fact pattern associated with our program today that will drive the hypotheticals. It's a Monday morning, and there's a high-profile drug conspiracy trial that's about to commence before the Honorable Judge Michael Barker. New glasses. I got these new glasses. I'm having a hard time adjusting. All right. Before coming to the bench 7 years earlier, the judge was the head of the DA's Special Prosecutions Division. He is considered competent, and the local bar associations give him positive ratings when he was initially elected to the bench. The 2 defendants are represented by 2 experienced trial lawyers, Tim Murphy and Harry Oliver, who are freely and fairly confident that Judge Barker will grant a motion to suppress a significant piece of evidence over the vigorous objection of the prosecutor, Nancy Miller. Ms. Miller is a career prosecutor who served in the DA's office under Judge Barker for a considerable period of time, and while together in the DA's office, Barker and Miller had a cordial relationship, but did not socialize outside of work. However, Judge Barker has recently become active on social media, frequently posting general comments about the legal system and his volunteer work, and he and Miller are Facebook friends. So hypothetical number one. After ruling to suppress the evidence considered central to the prosecution case, Judge Barker posts the following comment on his Facebook page. Quote, "Tough day in court today. I had to suppress certain evidence in a big drug conspiracy case, and am scheduled to speak to our high school kids at this week's Just Say No to Drugs assembly. Hope they still listen to our message." D.A. Miller responds by posting the following comment. "Don't worry, Judge, we still love you." An associate at the defense counsel's firm sees the post and notifies attorney Tim Murphy. That would never happen. So, Judge Egan, does the judge or the prosecutor have a duty to disclose their Facebook friend status?
Well, a lot of interesting issues, and just so everybody knows, many of these hypotheticals, almost all of them, are based on actual scenarios that have occurred. I often say I don't have a single original thought, and when it comes to the scenarios, I didn't need to. As most of you know, people do really stunning things on social media and in email. So I start the discussion of this hypo by just noting this is one of those things, just because you can doesn't mean you should do something. And I put judges as Facebook participants or friending lawyers under the category of no good can come of it. So frame our discussion and the answer to that specific question with a couple of points that are in your materials. The ABA Formal Opinion 462, a judge's use of electronic social networking media, as well as some elements, some specific rules of the Illinois Code of Judicial Conduct. Rule 61, charging judges with the responsibility to uphold the integrity of the judiciary. Rule 62, avoiding the appearance of impropriety. And Rule 63.7, avoiding public commentary about pending cases. The model Rule 1.2 mirrors Rule 61, promoting public confidence in the judiciary. So with those guidelines as our framework, I would respond to that first question by saying maybe. Lynn Egan personally would say, of course. I consider myself a disclosure gal. I think you can never go wrong by disclosing. However, if you look at the opinions from around the country, some of them suggest that the nature of the site, the level of the judge's interaction, the type of communications might influence whether or not the disclosure needs to occur. Personally, I would say yes. There should be disclosure, and especially in a criminal case. I think regardless of the issue, the reviewing courts take a much stricter view of things when we're dealing with someone's liberty, as opposed to, forgive me, Bob, mere money.
Well, there you go. I'm not going there. It's too early. I'm still struggling with these glasses. All right. However, I know a little bit about this recusal stuff, so should there be a motion to recuse the judge now that this little tit for tat is going on?
You know, I don't find anything in the model in the ABA rules or the Illinois rules. I would suggest, however, that there is a very well-known and accepted practical rule that supports the notion that a lawyer should at least consider asking for recusal, if not outright ultimately taking a change when it becomes apparent that the judge is a bona fide idiot.
Yeah. All right.
I would say, obviously, very, very poor judgment, potentially violates the rules of judicial conduct. And so I think the defense attorney in this case would be well advised to ask the judge to perhaps step aside. That post suggests the judge is concerned about his rulings, and the fact that the prosecutor feels comfortable enough, perhaps familiar enough, to reassure the judge, we still love you, Judge. Again, that could raise an appearance that there is not going to be impartiality. I'd love to hear what maybe...
Well, I was going to say, Mark, how about you? What's your take on this?
Yeah, what comes to mind is exactly the last words Judge Egan said there, is not just is there actual integrity breached here, but what's the context behind it? I think that one of the key words is context. And we have to remember, of the phrase social media, half of that phrase is social. It doesn't mean judges can't be social or can't have lives offside the bench. And not just in a large county like Cook County, a very large county, but the other 102 counties in Illinois, for example. There are some very, very small counties with literally a handful of lawyers. And maybe one of the lawyers is the sitting judge for the county. That does not mean they cannot have a social life together. Okay? We are human beings.
So is the answer then to, John, to bring this up in voir dire? I mean, you're a big firm guy. You try cases and they have...
Well, let me go back to the model rules. If you can put 3.5 up for a second, because prevention is what I would be focusing on. And you'll notice in 3.5 B, a lawyer shall not communicate ex parte with a judge, juror, prospective juror, other official during a proceeding. And the D.C. bar last November, how many of you engaged in multi-jurisdictional practice just outside of Illinois? Okay, some of you.
Fair number.
So, you know, under Model Rule 5.5 and the analog state rules, you can cross state lines now to engage in multi-jurisdictional practice, but you're subject to the disciplinary rules of that particular jurisdiction. So you do need to be aware of these conflicting opinions around the country. The D.C. bar, and it's a major social media decision or opinion that came out last November, just 3 months ago, essentially said under these circumstances, if you have a Facebook relationship or social media relationship with the judge, and then you end up in a proceeding in front of that judge, cut off the relationship during the proceeding. Just essentially don't have any more contacts, eliminate the friending relationship so you don't see posts and you don't send posts, and you can pick it up again when the proceeding is over. So if that rule were followed in this case, the lawyer would have never seen the post. Getting to your question, what do you do about it if it's occurred? I mean, I think you've got to discuss it with the opposing counsel, and if the opposing counsel raises it as a concern, the judge, particularly in a criminal case, I think the judge has really got to consider recusal.
Well, he didn't in this case recuse himself, and so therefore we're going on to hypothetical number 2.
Well, we do have an interesting question from the Internet. Remember
Sure.
the 4,000
Yeah.
that are on the Internet here. In a personal injury lawsuit where a witness or party and an opposing attorney were friends on Facebook prior to use in the matter.
Well, that's John. Would you take that one?
Yeah, I'll respond to that. We're gonna get to a variation of that question, but the answer is if it's public information, public part of the Facebook page, absolutely you can download it.
You know, one of the things that I think will come out of today's discussion is you start making a list for yourself. The rules of the game have changed. You got to walk into trial, and I think with a list of things to discuss with the court pertaining to social media, whether it's start from the get-go, whether it's we're going to defriend each other, we're not going to read our tweets while we're here, or there have to be some ground rules, and we can speak to those today, Judge, if that's okay.
Yeah, and I think that dovetails into, you know, Rule 1.1, competence, and before we move on to Hypo 2, should it be broached during voir dire? I think absolutely, if this judge is not going to recuse, and the defense attorney knows that has been out there, particularly in some of the small counties, there may be one judge, and everybody knows that judge is on social media. They may have seen it. So I think it would be, the defense attorney would be not just well-advised, but he would be remiss if he did not ask the judge to voir dire the prospective jurors about their knowledge of that.
Okay. Moving on. Hypothetical number 2 in your materials. Prior to jury selection, Judge Barker provides counsel with copies of the jury questionnaires completed by all individuals who will be part of the venire. The questionnaires contain specific information about the individual's names, ages, home addresses, phone numbers, and places of employment. Tim Murphy provides this information to his associate and tells him to conduct background checks on the members of the venire. I got an email just yesterday from a service that they want to provide you, the council with, on this very point. The following day, Murphy learns that the associate sent a Facebook friend's request to one of the members of the veneer during the course of his background check. This individual's uncle is an in-house lawyer for one of Murphy's other clients, and Murphy previously worked with him on internal investigation. When the uncle called Murphy to tell him about the associate's conduct, Murphy explained that it was a mistake. The uncle assured Murphy the matter was closed and that the juror would not say a word. Holy moly. What do you say about that, John?
So let me focus on the first part of this, just the access. And I don't know, how many of you have ever researched jurors on the Internet, or had it done for you?
A good number. I don't know of a trial lawyer today who's not.
Yeah. So if you put 3.5 back up on the screen, you'll see in 3.5 the word communicate. You'll see it, 1, 2, 3 times in the rule. And that's really the focus of the ethics opinions, is you may not communicate with a juror. So when you're accessing a social media site where a juror is involved, are you communicating with the juror? To go back to the question that was just posed with respect to a witness, the answer is no if you're only accessing what's available publicly on that Internet site. But what if the acronym that's referred to is ESM, the electronic social media? What if it automatically alerts the user that someone is inquiring or looking at that person's social media information? A lot of ESMs, electronic social media platforms, do that automatically. Are you now communicating with the juror? And so there is an ABA opinion that's out on this topic. It's opinion 466. And it says that it's okay to check out the information from the juror's public website. And it's also okay even if the ESM platform gives notice to the juror. The opinion offers this analogy. Checking up on the juror is like driving down the street and just observing the juror at the juror's home if you happen to see the juror. And then the reference to the ESM network notifying the juror would be the equivalent of somebody seeing you drive down the street and saying to the juror, oh, I know that lawyer, he was looking at what you were doing in the front yard today. And the ABA opinion says there's nothing wrong with lawyers doing that.
Well, how far can you go? I mean, is that like doing a background check on a potential juror? The judge gave a lot of information.
And so, again, as long as you're not communicating with the juror, you can go pretty far. But what's interesting about this area, and again, why you need to pay attention to the jurisdiction that you're in, is there are 2 New York opinions, city and county bar opinions, which refuse to indicate whether or not the passive notice to the juror through the electronic social media network alert that someone's looking at your website, they refuse to say that that wasn't a communication. The ABA opinion specifically disagreed with both the city and county bar of New York's opinions that didn't go as far as the ABA opinion went. So you must know your jurisdiction. Very, very important. I don't believe Illinois has rendered a decision in this area, Mark.
Judge, did those lawyers have a duty to report this to the judge? I mean, think about it. Now, it's like almost a little conspiracy here. Don't worry about it, Murphy. The juror won't say a word. Okay, that's our little secret here.
I think clearly the lawyers have an obligation to report, and if you look at Illinois Rule 3.3, candor towards the tribunal, also Rule 5.1, responsibilities of partners or supervising lawyers, telling the poor associate, mum's the word, you know, nobody's going to say anything. Guess who's going to be thrown under the bus when that juror says, before we start, Judge, I just want to let you know something. And, of course, then if the supervising attorneys don't do anything, Rule 5.2 speaks to the responsibility of the subordinate lawyer. So I think absolutely there needs to be that sort of disclosure, that sort of candor. And, you know, we get into this, you know, what happens then if they make the decision not to do so and then the juror outs them. then you are looking at a very, very uncomfortable conversation with your judge. And I can well imagine many judges referring you to the ARDC over that.
And speaking of the ARDC, Mark, what's your take on this one?
Well, I think that leads us kind of back to the beginning of let's be proactive, okay? And that's where you're going to see more judges implementing policies from the get-go. So it's about informing the jury before these things happen. And if they can do that and they can establish policies and briefings of the jury and set those parameters from the onset and solve the problems, then maybe the judges are going to explain enough to the jury for them to understand the seriousness of the position they're in. Many times they've never been on a jury before, and they know they need to step away from social media and all types of contexts for a while. And even ringing that bell online is just the same as ringing that bell in person with people.
So Judge, going back for a moment, do you instruct jurors to stay off of their social media during the course of their service, or how do you handle that?
I absolutely do, and actually, I was on the Illinois Supreme Court Civil Justice Committee, which a year and a half ago was tasked with looking at the topic of whether we needed rules governing jurors' use of social media during trial, and we undertook about a year and a half survey of all judges across the state, lawyers, judges, jurors, filled out questionnaires that covered a number of topics, and fortunately or unfortunately, at the end of that process, the committee decided that this wasn't enough of a problem to warrant recommending formal rules to the Supreme Court, but instead reliance on the IPI instructions was the way to go, and a similar result was followed in the federal courts back in 2011. And so I read IPI 1.01, the preliminary cautionary instructions, which were amended a number of years ago, to cover electronic devices, internet, all those sorts of things. The interesting thing, though, is I give them part of that instruction before opening statements. Many judges just give it at the end of the trial, which seems a little bit I always feel awkward reading that instruction at the end of the trial because it contemplates behavior that occurred before and during trial. If your judge doesn't bring it up, I would highly recommend every attorney ask the judge to read the preliminary cautionary instruction dealing with electronic devices and social media.
You know, there's another dimension here, John, and that is where now I'm picking a jury, I have the veneer, I have all this information. Don't I, in today's day and age, subject myself to being criticized if I don't seek out this background information and try to find out more about this prospective juror in order to make informed challenges during voir dire?
Okay, so the word I'm focusing on in your question, Bob, is criticized. Are you saying criticize rising to the level of malpractice?
Legal malpractice.
Yes, and so who's going to know whether the jury would have come out a different way had you asked a different question? But so the proof of malpractice, but competence and your conscience should worry you quite a bit, and certainly under Model Rule 1.1, Illinois 1.1, you have a duty to act competently, and that means gathering information on your jurors. Not communicating with the jurors, that's barred by 3.5. And as you all know, you cannot do indirectly what you may not do directly. So you can't have somebody else communicate with the juror. But no, competence plainly would require really everyone to gather as much information as you can on each prospective juror.
All right. So now we've picked the jury. We've gotten over all these issues about Facebook friends, but we're in hypothetical number 3. So before evidence began, Judge Barker instructed the jury that they were duty-bound to avoid any outside communications or information about the case. Yet, 2 days after jury selection was finished, an alternate juror who works as a teacher at the local high school approached the bench and told Judge Barker and the attorneys that a fellow teacher sent her a text message about one of the defendants. Specifically, the teacher wrote that the defendant previously attended the school where they both teach, that he was guilty of sin, and if she didn't recuse herself from the case, the defendant, if convicted, would be freed on on appeal. The woman told Judge Barker that she was angry at her friend but did not feel the text would affect her judgment. After the lawyers told Judge Barker that they had no objection to her remaining as an alternate, the judge asked the woman to text her friend and tell her to stop sending messages. The woman responded by asking, "Why don't you do it?" After she handed Judge Barker the phone, he typed and sent the following message, which he read into the record. Quote, "This is Judge Barker. Do not send any more text messages about this case or there will be consequences." So, all right. Judge,
You didn't make this one up either, Lynn, right?
I did not make this one up. This was
Whoa.
reported in a New York newspaper about a year ago. It was fresh enough, and I frankly hadn't followed it. I don't know whether it generated any disciplinary complaint against the judge, but again, I don't have a single original thought when it comes to these fact patterns, and don't need to. It is a real case.
So was the original text message to the alternate juror a basis upon which to declare a mistrial? What do you think?
I don't think so, but it's sort of interesting. Certainly, I think it prompts an obligation on behalf of the lawyers to request an in-camera examination of the juror. If you look at some of the cases cited in your materials, People versus Harris, Supreme Court decision from 1988, they talk about any communications with a juror is presumptively prejudicial, and in that case led to a reversal. Interestingly, however, that by 2009 in People versus Runge, the Supreme Court was using different language, saying not every contact even requires putting the juror on the spot to question that person. So it's interesting to me there's been an evolution. You will still see cases where they cite that language about context being presumptively prejudicial, but I think all of the courts are understanding now the prevalence of social media and this sort of communication. The twist to this is, at first blush, it doesn't look like the juror, the alternate juror, did anything wrong. Somebody reached out to that person and made a request. However, how did the coworker know that she was on trial, a juror on a case involving one of their former beloved students? Obviously, the juror must have spoken about it to a certain degree.
And so would your analysis have been any different if the alternate juror had responded to the coworker's text message?
Maybe, because now the juror has actually violated the court's not just instruction. In my courtroom, not only do I instruct them according to the IPI, but I also tell them, consider this a direct order of the court.
Mark, what do you think? Was there any reason for the lawyers to object to Judge Barker's text message to the alternate juror?
Oh, sure, and this is where I think the judge, there's a lot of deference put to the judicial investigation that needs to happen here. So stepping back, if the judge is looking into this, the judge also has to be considerate of how are the other jury members going to see this too, and that takes into account. And courts have reviewed this both at the appellate level and the Seventh Circuit level recently have said, take account into, for instance, bringing them in camera, the other jury's members are going to be aware of this. And so that in and of itself, the investigation process has to be careful because you may only compound the same problem of an impropriety or a perception of an impropriety occurring. So the judge does not have an easy job, again.
John, anything to add?
Nothing to add.
We have a question from the internet from Chris asking, is an opposing attorney required to defriend a litigant who has sued his client?
Defriend a litigant who has sued his client.
Yes, an opposing attorney required
No.
to defriend a litigant who has sued his
So
client.
it's unrelated to this particular
It's not related to
hypo.
their topic.
Well,
Yeah.
I think required is too hard of a word. I think it just again, the key word is context. What's the context? What's
Yeah,
the environment
intro-
that they are friends to begin with? Is it just because that person is a spouse of your real friend or a former coworker?
So Clifford represents Smith in a PI case. We sued Jones. My buddy represents Jones, but we're friends on Facebook. I don't think that
Previously
follows.
were friends on Facebook.
Yeah, that doesn't follow. I think the answer is a no, solid no.
So-
Okay, let's go back to our trial. On hypothetical 4, it's been a couple weeks now where this trial moves along quickly. You blink in social media and the world changes here. So after 2 weeks of trial, in this case the following Monday, Tim Murphy directs his associate to deliver exhibit binders to the courtroom. When the associate arrives early Monday morning, he finds the courtroom locked, so he retreats to the coffee shop in the basement of the courthouse. As he is sitting and enjoying his coffee, the associate overhears two men at an adjacent table discussing what sounds like Murphy's case. He hears at least this much from the conversation. Man A: "I didn't like that Snow guy, so I Googled him over the weekend. You know what? This so-called PhD left one of his university teaching jobs after being accused of plagiarism. I just knew that guy was a phony." Mr. B: "Judge Barker told us not to do that and that we should not be talking about the case." Back to A: "You're right. Forget we had this discussion." Murphy directs the associate not to say a word about the jurors' conversation. Wow. This is another one. Mark, what do you think? What's a lawyer's duty to report the juror misconduct there, or is there misconduct?
Well, clearly, due process requires the jury members, the jury itself, to apply solely the evidence before it, not the evidence the jury member found online. And, of course, as technology advances, the ease of doing so advances. And we're going to see more and more of this type of example.
Okay.
What type of candor to the tribunal, I think, is required here, and that's where you need to start your examination. Is this a criminal act or a fraudulent act? Is it that serious where an immediate, required, reasonable remedy of misleading of the jury at issue?
Well, here, clearly the juror did something the judge said don't do. And so that's an issue. The other issue, of course, is the senior lawyer telling the younger lawyer, don't say anything about it.
Yeah.
Now, I'm sure that if the shoe was on the other foot and the counsel didn't like what that juror was saying, might have had a different view. That's not right.
Sure, and the associate lawyer, under Rule 5.2, can fall back on, oh, I'm just doing what I was told by my boss, the partner or the senior lawyer, but that does not still waive that lawyer's, the associate lawyer's, duty bound to the rules of professional conduct. It's clear.
Judge, let's assume these lawyers did the right thing and they did come to you with this problem. What should the lawyers be requesting of you? What kind of relief?
Minimally, they should be asking for in-camera examination of both of those jurors. Importantly, you must create a record because, if you look at the SQ versus Burlington case, which is in the written materials, you have to be able to demonstrate, if you're the aggrieved party after the verdict comes in, that the information that was introduced relates directly to something at issue and may have influenced the verdict. If you don't have an in-camera examination, you're not creating the necessary record that will give you the ammunition you need post-verdict. If you're opposing any such in-camera inspection, you can cite the Zaragoza case or the McGee case, and those are interesting. Both SQ and Zaragoza 2011 decisions out of the same panel of the First District reached opposite conclusions.
There we go. Well, we're going to the Supreme Court with that one.
Okay.
Although I can't help but inject myself here on this one, and you all might be coming to this topic later on, but there was a recent opinion coming out of the federal court where a justice on the appellate court is doing collateral research out.
Standing Committee on Ethics and Professional Responsibility, and we are actually working on an opinion on this very topic right now, so stay tuned.
Stay tuned. Okay.
But there is the judicial code of conduct that judges follow does speak to this issue. But let me just be an academic for a second and mention ABA Opinion 466. You may be surprised to learn that you're limited under the model rules and the Illinois rule to reporting misconduct only if there's fraud or criminal activity by the juror. Rarely is misconduct, as described here, going to rise to that level.
Can I interrupt you? What if we consider this indirect criminal contempt?
If you can, as a lawyer, rationalize that this somehow falls into that arena, then you absolutely have a duty to react. And the ABA opinion 466 seems to be reaching as far as it can to say to lawyers, report, 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 even though it may not fall into the category of criminal or fraudulent, because I think the presumption is that you really should report. If you were in New York State's version of 3.5 actually says the following: a lawyer shall reveal promptly to the court improper conduct by a member of the veneer or a juror or by another toward a member of the veneer or a juror or a member of his or her family of which the lawyer has knowledge. The model rules do not contain that phrase. When New York adopted the model rules about 5 years ago, they added this particular language to 3.5. So know your jurisdiction, and then to Lynn's point, to Judge Egan's point, know your case law, because in a lot of jurisdictions, the issue is going to be controlled by case law if you can't fit it into the fraud or crime category.
Well, and also just as an addendum to that, look at the terminology in the Illinois rules. Rule 1.0 defines fraud as having a purpose to deceive. So we take those decisions that say you only have an obligation to report fraud or criminal activity. Okay, maybe you don't want to say that disregarding a direct order of the court is contemptuous. Is it fraudulent? Is there a purpose to deceive here under the Illinois rules? Also, 3.3, Illinois Rule 3.3, candor towards a tribunal. The preparatory language is that attorneys have special duties as officers of the court. And then on the practical side, your reputation in front of the court. You're probably going to be back in front of that judge someday. Do you want the first thing that judge to think about is that you covered up something like that? I guarantee you, even if the ARDC didn't do something, it's going to be a pretty frosty reception in that courtroom, and judges talk to one another.
And so, if I can just summarize then, the ethics rules sometimes really don't matter. It's always the right time to do the right thing. You're not going to risk your reputation because you think you can skirt an ethics rule that doesn't quite fit.
Yeah. Well, and in this example, hindsight could be 20/20 a few years later when you're trying to get a new trial for your client and you're realizing you did not timely bring this to the court's attention, and the court is going to realize that and say, well, your time is up and you've waived it.
Well, let's give another variance of this in our next hypothetical, number 5. So now we're 2 days after 2 days of the defense case, a juror sends Judge Barker a note indicating that she needs to speak with him. With the attorneys present, Judge Barker brings the juror in the chambers and learns that another juror mentioned he used the Internet to look up information about drug conspiracy trials, and that another juror made the following post on an Internet blog, quote, "Being a juror on a criminal case is a real eye-opener. Defendant's attorneys say it will last another 3 days, but all that's left now is deciding how much prison time." Wow. How about that one? So
And guess what? It's not made up.
Huh? So, Judge Egan, does the judge have an obligation to question the two other jurors, or should the judge question all the jurors to determine whether they know of these activities, and if so, whether it's affected their ability to remain fair? And do the lawyers have an obligation to make a motion for a mistrial? What do you say?
Starting number 1, does the judge have an obligation to conduct an in-camera examination? Absolutely. Start with the 2 that are involved, or the 1 that's involved, and then go from there to see if further inquiry of the other jurors is warranted. And this topic, I think, really requires you to appreciate the case law on impeaching a jury's verdict after it's been received. You know, we all know People versus Holmes. You cannot impeach a verdict by getting into the means and methods by which the jury reached that verdict unless you have some evidence that extraneous information has been introduced into their discussions, like this information this juror got off the Internet. Or there was one case, it was an auto case, and a juror brought in a Rules of the Road booklet. Extraneous information brought into the jury room. Doesn't matter what the jurors tell you later, this is your golden opportunity to create a record that may enable you later to have a successful post-verdict challenge. You have to be able to prove, quote, a probability of prejudice. And there's an interesting Illinois case, Waller versus Bagga, B-A-G-G-A. The bailiffs, sometimes it's not the jurors. Sometimes the deputy sheriff, in that case, the sheriff said to them repeatedly, this case should have never made its way to the courthouse. And unfortunately, the judges, we don't get to choose who our deputies are. oftentimes we'll have a different deputy every day of a trial, and so we won't know what they are saying to these jurors. So if it comes to your attention, I think you, as an attorney representing your client, you need to take advantage of the opportunity to create the record.
Mark, what's your take?
Well, I think going to the beginning of this and conducting the in-camera interview, you know you have a big problem here because it's not just two jury members are communicating. You have the third person reporting the communique, so you almost have to have a built-in assumption that everybody is talking about this behind the scenes, and that should weigh into your factor. And that kind of goes to my point of the judiciary needs to understand how social media works, too.
Yeah. John, how about you? What do you think?
I really have nothing to add. This one seems pretty open and shut to me.
Yeah. Well, the only footnote that I know of is that bailiff that the judge was talking about a moment ago, after the judge said, why don't you all go in there and figure it out, we're going to let this go. The bailiff goes into the jury room and says, you know, it is Thanksgiving Eve. The judge said that if you don't get a verdict pretty soon, you're going to have to stay tomorrow. And within 20 minutes, they had a verdict. But mistrial declared. Okay, this trial is over. And we're going to switch gears to another area that's of keen interest in the social media world, and that's friending on Facebook. So hypothetical number 6, receptionist to friend the witness so you can gain access to the witness's Facebook entries, which are not publicly available. Is there any ethical problem associated with that?
So don't switch to the questions yet, Bob.
Okay. Any ethical problems
So
with that,
let me
John?
start. Actually, it's audience participation time. I'm curious, who in the audience thinks that there's an ethical issue here? Okay, so someone, who's raised your hand that's close to one of the mics? Over in this corner here? Who had their hand up over here?
Yeah, we got 2 roving mics here.
There you go, number 3 in the back there, right back there, right there, that person right there. So tell us, sir. Tell us who you are.
My name is Hall Adams.
And what ethical issues do you see?
Well, the receptionist is the lawyer's agent. That's the issue. It's no
Okay.
different than if the lawyer had...
Okay, well, so you're saying the receptionist is the lawyer's agent, but what's the significance of that?
Well, a lawyer communicating with anybody has an obligation to identify himself or herself as a lawyer representing a party.
So who shares that view? A lawyer has a duty to identify himself or herself in contacting anybody. Anybody who disagrees with that?
Yeah, I do. I want to, here, wait a second here. Let's not go too far with this stuff. So let me get this right. It's a witness, an independent witness, been subpoenaed presumably for a debt. Not a...
Anything wrong with gumshoe detective work? You're just doing gumshoe work?
Miles, you didn't raise your hand, Miles Bierman. I know one of the most esteemed members
Someone
of our
else have
bar
a
here.
reaction to this? Right here, we have a...
I don't need the mic.
Well, you do because the people on the phone may not be, people on the internet may not be able to hear you.
I'm Lisa Taylor. I guess my concern or the reason that I find an ethical issue is because the information is, quote, not publicly available. And to me, that signals that that would not be appropriate for me to have someone that I supervise. That's the 5.1 Judge Egan talked about.
Well, so Lisa, this particular witness loves friends. In fact, is in a contest to see how many friends this witness can have compared to her other friends. And anybody who friends this witness is allowed access. That's just the way the witness is.
And that may be fine, but in the context of knowing that the witness is going to be a deponent in a case, I just still don't think it's appropriate.
Well,
That
let me ask
doesn't
you,
change my position.
is it okay if you're trying to ferret out copyright infringement or trademark infringement to send a buyer into a store, pretend to be a buyer, and then buy the goods and then prosecute the infringer? Or is it okay for someone who claims there's housing discrimination going on to put up someone to pretend to rent something called dissemblance? Is there a difference between that and what we've just been talking about?
I don't know about the patent and trademark because I don't do that, but I will tell you inherently as one of the few people of color in the room, I'm okay with the housing issue.
Okay. So,
Amen, all right.
so let me,
Okay.
so let's
John,
be academic for just one
all right,
second.
where are you going with all this?
So let me explain the history here. It's a fascinating history. Know your jurisdiction. The first opinion in this arena came down in 2009, the City of Philadelphia Bar. All this is covered in my very robust paper, so you can take notes or read the paper, whichever your preference. City of Philadelphia said what most of you indicated. you're engaging in deceptive conduct. That's 8.4C. You're engaging in deceit or dishonesty by trying to friend a witness without disclosing who you are. And absolutely, you can't do it indirectly under 8.4A. Well, so that's also prohibited.
Through the agent.
Yeah, through the agent. San Diego bar then comes out with an opinion mimicking the Philadelphia opinion. Then the New Hampshire bar comes out with an opinion also mimicking the Philadelphia opinion. Then New York, it's the City Bar of New York. They're city, state, and county. You have to get them all straight. City Bar of New York comes out with its opinion, and the question framed involved the word trickery or deception, and the City Bar said, therefore, we agree with Philadelphia, but the City Bar went on to say that a mere friend request, not being deceptive, if your profile is on the social media page, your lawyer profile is on the social media page, and you friend someone, and that person can look you up, that's okay. The State of Oregon Bar then came out with an opinion that essentially said the burden is not on the lawyer to disclose who the lawyer is, the burden is on the person being friended to make inquiry. And if the person being friended makes inquiry, the lawyer must accurately describe what the lawyer is doing and why. 4.1, truthfulness to others. Massachusetts Bar then comes down with an opinion that says New York's wrong and Oregon's wrong, Philadelphia's right, the others are right, this is deception, this is dishonesty, you may not engage in it. And then in November, to finish the litany, in November the D.C. Bar just came out with an opinion. I've just taken you from 2009 to 2016, by the way. In November of 2009, the D.C. Bar agreed essentially with Massachusetts and Philadelphia and the others that say it is deceitful. So with that, I'll turn it over to Lynn and Mark for their views.
Wow. All we wanted to know is if the guy on Facebook said that he really didn't see the accident, but now he's going to give a dep about it. Okay.
Know your jurisdiction.
Know your jurisdiction.
Lynn, Mark, you guys have reactions?
I agree completely. You can't do indirectly what you couldn't do directly.
So, but here's, I guess, what we're saying, that this gumshoe detective work is probably a lawyer's obligation to engage in, but they have to do it the right way.
Absolutely.
Mark, is that what we're saying? I mean,
Right. You can't forget competency. That's why it's put at the top, 1.1. It's right there at the top, and that now includes with Common 8 in Illinois, and the majority of jurisdictions in the United States includes technology.
Mark, you got to describe the Chancellor opinion for everybody, though.
Yeah.
People need to be aware of that.
Tell us about that. That's In re Chancery. It's a 1994 opinion. Local, ARDC opinion.
A father takes a child across state lines to Mexico, demanded to bring the child back. The father's lawyer doesn't actually use the fake opinion, but does convince the father to bring the child back, and you can take it from there.
Yeah, and if I recall, the emphasis was not on the fact that it wasn't used. The emphasis was on the fact that the lawyer still engaged in creating a false and misleading statement, a fake order of the court, and that was what drew the attention.
Right, and the lawyer was disciplined for doing what the lawyer thought was a noble act to get this kid back into the hands of the mom. But so you do need to be aware. There's a question, two questions back there, one in that corner and one up there.
I assume that you're familiar with the television program Bull, and it goes to jury selection and finding out about jurors. And it seems that every week the undercover or former FBI agent goes undercover and falsely gets into people's homes and gets the background information, and Bull always wins the case, or the lawyer he works with. Are you telling us that they are, this is totally dramatic license, totally unbelievable, not based in reality whatsoever?
If you look at the most recent edition of Chicago Lawyer, there is a column by yours truly that says just that. The Bull show is a bunch of bull.
So let me add some legal context to that. These are just decisions from last year. Lawyers sitting in a conference, on a conference call, not disclosing that the lawyer was present to the person at the other end, who allegedly made some damaging admissions. The lawyer kept notes, and then that particular party wanted to use the lawyer's notes and admit them into evidence. and the court suppressed the notes because the lawyer failed to disclose that the lawyer was present on the conference call. 4.2, anyone know what 4.2 says? If a person's represented, and by the way, even within these various opinions, the first thing you always want to find out is the witness represented, because you may not make contact with the represented person without consent. But citing 4.2, the court suppressed the evidence, and then just a few months ago in New York, and these are federal district court decisions, Uber hires an investigator to investigate a plaintiff driver that was suing Uber. The investigator, using false pretenses, starts to make inquiries of folks to learn more about the plaintiff. The lawyer for the plaintiff gets wind of it, contacts the defense lawyer and says, what's going on here? Defense lawyer wasn't told that this investigation was going on, said, no, we're not doing anything. Turns out that the investigator was not licensed in New York to conduct investigations. Court got wind of it, all came out. The demand for the work product of the investigator, work product was claimed as a defense. Court invoked the crime fraud exception. You think it's just attorney-client privilege. Crime fraud exception to the work product rule, invoking New York's fraud statute, required all the work product to be turned over, and only because Uber agreed to pay all of the plaintiff's fees and costs associated with that particular matter did the court elect not to consider whether there was a 5.3 violation. Both Judge Egan and Mark have mentioned it already. You have a duty to supervise non-lawyers, so you need to pay attention if you're hiring investigators. In my paper, I discussed the two areas of law, the case law. Gumshoe detective work, okay. Engaging in false pretenses or other practices which rise potentially to the level of deceit or dishonesty or fraud, not okay. Know your jurisdiction, make sure you've got reputable investigators, and don't engage in false pretenses. You had a question, too, up there. I don't know if you still have it.
It was around what Bob had said earlier, that people are doing social media investigations. And if you hire this out and they begin to make false representations, you're going to be in violation.
Yeah, if they're under your supervision. Now, I will say the New Hampshire bar opinion raised this question. Suppose the client does the research and the lawyer has had absolutely no involvement in the client's actions, didn't put the client up to it, may or may not be provable, but let's assume that to be true. The New Hampshire bar opinion says that's okay. The client does it without any involvement from the lawyer, no prompting by the lawyer, clear innocence by the lawyer, then you can use the information.
Well, that goes back to our hypothetical here. If the client successfully friends, you know, going back to what got us here, this witness who's coming in for the dep, you know, what if the client friended that witness without the lawyer's knowledge? Does that change anything?
Well, the only opinion I've seen on it is the New Hampshire bar opinion says it's okay.
Yeah.
Well, again, as John said, know your jurisdiction. Illinois Supreme Court Rule 219C says can't use any information that's been obtained through an abusive process. So that could be a viable argument, even if the lawyer is completely blameless, for a judge to say, I'm not going to allow you to use the information.
Well, if you think through the practicalities of it, you know, so let's assume the client does the friending, lawyer legitimately doesn't know about it. Now the client comes to the lawyer and says, hey, John, guess what I found out? I mean, don't you still, the problem isn't going away.
I don't know that it would rise to the level of abusive process, but it's just another item on your checklist to think about.
Yeah.
We have a lot of questions flying in on the internet here.
Associated with this hypo or
Well,
discussion?
he was asking, it has to do with Facebook. Can a lawyer friend a judge on Facebook or LinkedIn if they appear before them? And then we have from Maura asking, what if you friend or connect with a judge through Facebook or LinkedIn through the clerk? What if you're not even before them?
I say this to judges when I speak at judicial seminars. Facebook friending with lawyers, no good can come of it.
Right, that's my view, too.
And
Even if there's no ex parte communications regarding any pending cases?
yes, and Mark and I were talking about LinkedIn. I have, since the time I got on the bench and LinkedIn took off, I have declined to be part of LinkedIn. Initially, when LinkedIn, you know, became a thing, It was using your connections to benefit people. I believe that's a violation of the Code of Judicial Conduct. I'm not able to use my position to further the interests of anybody else. So I think it's a very unwise thing for judges to be on LinkedIn, and I think being on Facebook is a problem, because then, okay, if the lawyer appears before you, okay, are you active on Facebook? Do you remember who's your friend? Do you have to defriend them? Do you defriend them for every appearance, a case management conference versus a trial? I just think it creates more problems than it's worth. I don't know what you think.
And is there a grace period afterwards? Then you can become friends again. But the point I want to raise is it goes to the type of social media it is. And Facebook and LinkedIn are very different, and we're going to have all kinds of new platforms coming down the road. So, for instance, and I was talking to the judge, how LinkedIn has evolved into not just being about connections, but now it's also a news source where someone goes for their news reporting and to see what other people are sharing and to join groups within the platform. And so things evolve, and it doesn't mean that the judge can now join just to read news, but you have to have consideration of technology evolving.
Let me say something provocative here. And it speaks, Mark, exactly to what you just said, that now LinkedIn is more than just, getting together. Twitter's the same way. That there's so wouldn't we just be better off, because the genie's out of the bottle? I mean, Mark Zuckerberg right now is talking about using Facebook, artificial intelligence, to identify terrorists, okay? I mean, this thing is just going to grow and grow and grow. Shouldn't the legal profession simply say, let's develop, robust rules of conduct for the lawyers, and rely on the fact that they should be following them, and forget all this stuff? You want to friend a judge? Friend them. You want to investigate a juror? Investigate them. But, follow the rules of professional conduct. Why isn't that the law? Or shouldn't it be?
I think that's why we have to have flexibility in the rules, and that's why we take very time and consideration to develop these rules and make them flexible, because we are seeing not just change, but exponential fast change. And to take an example, going back to the jury research, in the past it may be a lack of your responsibility as representative counsel for the defense, say, to look into the backgrounds of the jury's criminal past. But maybe now that's elevated to a new level where you have a duty to look onto their social media presence as well. And is that duty going to continue to percolate up and up into new platforms and new areas? And you can't change the rules specifically to address each and every one. You have to make them flexible.
And I'll give you two other perspectives. I do a lot of work as a neutral, not a judge, but as an arbitrator, as a mediator. I have to make disclosures all the time. I don't want to add to another disclosure, so I don't participate. I follow Judge Egan's rule. I don't participate in any of these platforms because I just don't want to be in a position to have to disclose that I'm a friend with someone. And then the flip side of it is, if you've got someone who you think is a really good judge, do you want to run the risk that that judge may recuse himself or herself because if you end up in front of that judge because you're on a social media platform with that judge and you're part of a friend network? Why take that risk too? Because you want good judges for your cases. So there are. It's an area where I just think from a judicial standpoint or a neutral standpoint, you're best served by staying away from it. And I get lawyer requests all the time. I just ignore them, friending requests all the time.
Just think about it, just sort of the flip side. You're charged with complying with these rules. If you Facebook friend a judge, the judge not once in 20 years opened an email. They don't text. They don't know the scope of what these sites do. So do you want to have to worry not only about your own conduct, but whether the judge you have friended knows enough about the firm? You're very active on Facebook with this particular judge. Your partner appears before that judge. Does the judge need to disclose that? Do you need to clue in all of your partners and the associates that you're good Facebook friends with the judge? It just is sort of an endless traditional means of social interaction.
I had this very issue just 2 weeks ago. A lawyer called me up asking for advice. He's a very good friend of a judge, socially, not necessarily on a social network, but socially, and case in front of that judge by one of the other lawyers in the firm. He told the lawyer to disclose to the other side that he's a very good personal friend of the judge. So it could be a country club issue as well as a social networking issue in terms of an analog. But you make your disclosures, and if the judge feels that the judge can't honestly and partially decide the case, the judge is going to recuse himself or herself. That's the practical effect of all
All right.
this.
There you go. Let's, a question in the audience here, and then we'll turn to our next hypothetical.
More of a comment than a question, if you'll allow me.
Sure.
Listening to this, it almost says that the judge goes into the courtroom basically having no more knowledge than a newborn baby. I mean, one thing is to send somebody surreptitiously and, make a friend of one of the parties or this kind of a thing. Of course, that's wrong. But this stuff here, where people put it out, there's no connection that you have with that person. They just have information that's out in public. And when they do that, they're making it available to the public. I mean, whether it's tweeting or friending or any of these other things, it's not that you have to pretend to actually be
Yeah, sir, if there's really not an issue if it's publicly available. There's really no prohibition on you gathering information that's publicly available. As a lawyer, judge doesn't want to do independent research, I don't think, but as a lawyer, you can certainly gather any information that's publicly available.
There you go.
As long as
Okay.
you do it under your true identity.
Yeah, but I mean, all this stuff's out there. I mean, you're talking about now looking at a newspaper, or you can say, well, but you can't read an article on this. This stuff is out there.
Yeah,
and
no,
it's
if it's publicly available, you can access it.
I think the distinction between publicly available and friending somebody, on these networks.
Are you on a network?
No,
Okay, so do you understand the difference between a private page in Facebook and a public page in Facebook?
no.
So that's the distinction. A public Facebook page I can access right now, but a private Facebook page I can only access if I get a friend request accepted by the holder of the account. And that's what we're talking about, is the information that's not available publicly.
We have an interesting question from the internet, and that is, what's the difference between friending a judge on Facebook or the judge's campaign for election or retention with Facebook?
Well, I think that's a great question, and a lot of judges that set up a Facebook account for purposes of election never shut them down. They sort of stay somewhat active on it. I think that there is a legitimate, I guess, reason to be served when you're running for election. You want to be able to get your punch number out there, minimally. But again, I just think there's no sort of valid benefit to anybody by a judge being Facebook friends with lawyers that appear before him or her. Also, in terms of election, judges are supposed to be insulated to a certain degree. You have to have a campaign committee. You're not supposed to know who's contributing to your campaign. It's always been sort of funny. I like the skeptical look. You certainly know who's contributing when you go to a fundraiser and you see who's there, but there's supposed to be some buffer between the judge and people who are contributing to the campaign.
Let me just add, but I know we need to move on, but there is a First Amendment tension to the latter issue. There's no First Amendment tension to the former friending a judge is. I just think it's a bad idea for the judge to participate.
All right, one more question from the floor.
Right, I think then if
Tom Aaron's my name. I understand the general rule, arbitrator, nothing to be gained on Facebook. Judge, nothing to be gained on Facebook. Attorney-client, Facebook. Duty to communicate with your client, even former clients. Unsolicited friends requests from a client many years ago. Will you be my friend? Confirm or deny?
No problem with that.
No problem with what?
Yeah,
Not
just a
answering?
client friending the lawyer friending the client?
Or I mean just ignoring the request.
Oh,
Does an
Oh.
attorney have an
Is-
obligation?
You didn't like that
to-
client, so,
Well, it's very, very simple. We're not on Facebook with the client, but we could become on Facebook simply because we got a hit from that.
It's a business relationship question to me.
Okay.
It's not an
So-
ethics
yeah.
question.
So the non-answering of it is not a lack
yeah.
of...
Well, the
appropriate-
real issue is going to become when you say yes, and then tomorrow the client says, hey, Tom, I just had this thing occur to me last night. What's your advice?
Right.
That's going to be the real
Or
problem
the
you're gonna have.
decline, meaning what do you mean you're supposed to you were my lawyer. I meant
right.
the non-responsiveness. Does that trigger?
But the
a vi-
representation's over.
It potentially could still, maybe that's a
Yeah,
different question. but
okay.
Yes.
That's a different
Right,
question.
right.
All right. Let's
Thank you.
get, thank you, Tom. Okay, let's move on to a new thing that, from law firm marketing perspectives, is something that is, it's here to stay. Hypothetical number 7. A lawyer registers with AVO, a website devoted to obtaining user evaluations of lawyers. The lawyer calls some of her client contacts who have also become friends and asks them to go to AVO to rate her. They do, with glowing testimonials about the lawyer's skills and tenacity. The State Bar discovers the testimonials and directs the lawyers to unsubscribe from AVO. The lawyer is willing to do so, but AVO refuses to remove the lawyer's name or the resulting lawyer evaluation. So before I get to my questions, do these facts create ethical jeopardy for the lawyer? The First Amendment issues here? What do we have to say, John?
I'll start off, but I'm curious, as a show of hands, who thinks that there's an ethical problem here for the lawyer? Testimonials are banned in several state bar ethics rules. Who thinks there's a problem here?
No one from Chicago. Oh, one person from Chicago.
One.
Out of 100.
So if you're advising the lawyer, what would you advise the lawyer to do? Anybody want to answer that question?
Well, how's this different than puffing? Come on, you tell me that bicycle I bought is the best one that Schwinn ever made.
Yeah, well, the problem with testimonials, of course, is that somebody, an unsuspecting consumer, might decide, well, geez, if you got that result for that client, then you're going to get that result for me, and that's why we have bans on testimonials, and I think it's in 12 states, and then restrictions on them, I believe it's in 5 other states. I don't believe Illinois bans
But
testimonials.
aren't these lawyer advertising? Isn't this just
So this is,
lawyer advertising?
let me start with this just fundamental principle. The advertising rules are in chaos, period. 7.1, 7.2, 7.3, 7.4, chaos. Advertising, solicitation, and then advancing specialties. That essentially covers 7.1 to 7.4. The states have essentially taken those rules and created their own set of rules. You can't know from state to state what the rules are. You go to the ABA, Center for Professional Responsibility website, you'll see a chart showing which of the advertising rules have been amended by which states. 36 states have variations of the rules, so you can't know. The Illinois is pretty close to the model rule, so you can pretty much look at that. There is now a proposal before our committee, the Standing Committee on Ethics and Professional Responsibility, to change the model rules to have a very simple rule. This is in the Bob Clifford arena. A very simple rule that simply says you may not engage in anything, every advertising that's false and misleading, sort of, period. And there's a little bit more to it than that, but essentially to try to keep them very simple and then not to worry too much about whether or not something like a testimonial needs to be dealt with. This particular case is, again, a real case, to follow Judge Egan's lead. In Florida, I think was actually set up, and the lawyers sued the bar, claiming First Amendment protection, and that case got settled, and the bar agreed that if the lawyer couldn't remove the testimonials because ABO refused to remove them, then the testimonials could stay.
What if the lawyer paid for the testimonial?
Well, so, and you're a great setup man. So there's a recent New York opinion. I got to look to see whether it's city, state, or
It's state.
1052.
yeah, 1052. It's either city or county opinion. I don't recall which one it is now, and the facts were a lawyer agrees to give a $50 discount to the client if the client writes a review after the case is over of the lawyer's performance. Anybody see a problem with that? Who says there's a problem with that ethically? Raise your hand. Okay. Well, the bar said as long as the lawyer plays no role in coercing the client to say anything favorable so that the client is free to be negative or positive, it was ethically acceptable for the client to do that, for the lawyer to do that, to offer a $50 discount. There's also I call it the Groupon opinion, where if there's a special lawyer's discount participating in Groupon, is that permissible? And again, either the city or county. So many of these opinions come out of New York, and again, it's in the materials, said that that's also okay, again, within certain parameters. But the question always is in these opinions, is it advertising? Is it a solicitation? When you're dealing with these kinds of issues. For testimonials, you don't want to be in South Carolina, because South Carolina not only bans them, but has issued some opinions that directly go after AVO. And in this state, Mark, maybe you can comment about Illinois' views with respect to AVO.
I think the important factor has been that I've seen, if you accept AVO and you claim your profile, you need to be sure what's on that profile is accurate. Okay, you have control over it. And I'm talking separate from attorney reviews or client reviews of yourself, but the content that's on that page. You, of course, should not inflame it or make sure it's not misleading. You have the power to control what's there, so you have the power to edit it and make sure it's appropriate.
Hey, Mark, how about this one? We recently were, in my world, it's not uncommon for clients to interview different law firms to see whether they want representation from your firm. And in this one recent aviation matter, one of the other firms involved, on their website, they said, aviation specialists, and there's this thing called Wayback where you can look at somebody's website like on a given day. So we happened to look at their website the day before the crash, and it had nothing about aviation expertise. Well, how about that stuff like that? What do you think?
Yeah, and that goes to the prohibition of specializations except in certain circumstances, and there's continualization of carve-outs of different specializations are allowed. Patent lawyers for one small example, but there's others. But you're seeing that as these platforms are developed, they want to make themselves different than other platforms, so they're going to have ways to let that attorney stand out. Or if the clients and potential clients are going to these websites, they have to find a way to filter to find the right attorney for them, quote unquote. So that's where some type of designation in the attorney profile is required. Location and other things, but also what type of work they do. But that can be a slippery slope.
So, Bob, I'll react to a specific case in that regard. Last year, a federal district court in Florida found unconstitutional under the First Amendment a bar prohibition on a law firm saying it was a specialist in mass tort litigation. It was undisputed that the law firm, this is the Searcy Denny firm, undisputed that the law firm was a specialist in mass tort litigation. Florida doesn't have a specialization program for mass torts. It has a certification program for specialties, but not one for mass torts. So it was a truthful statement, and the court held, applying a Supreme Court case called Central Hudson, and you'll understand the factors. Does the bar have an interest in policing the matter? Is the restriction that the bar has imposed the least restrictive means to achieve the objective? That's the purpose of the restriction. And the court held that this was commercial speech protected by the First Amendment, and the bar's prohibition on truthful information didn't satisfy the Central Hudson standards, and found the advertisement on the firm's website to be permissible, even though it was inconsistent with the bar rules.
Although it's a problem in Illinois, right, Mark?
Right.
The other, before we leave this...
problem in Illinois, but maybe a violation of the First Amendment if it's a problem in Illinois. Because I don't know if Illinois has a specialty for mass torts.
No.
So, again, you've got the First Amendment tension in these areas of truthful commercial speech.
Another, just as an aside, even if it's permissible, do you really want to do it? I personally disagree with the New York Ethics Opinion 1052, which John has referenced in his written materials. And think about it. Clients are oftentimes at their most vulnerable when they are in your office. Do you really want to be perceived as preying on that vulnerability, particularly in some of the divorce proceedings, child custody proceedings, people that may be really hard-pressed to even pay your bills, and you're going to be perceived as perhaps seeing an opportunity there, offering them a $50 credit when they may not feel the ability to resist your request to post a testimonial? even if it's permissible, I don't know that you want to do that, especially in the domestic relations world. That generates more sanctions and I think probably complaints to the ARDC than a lot of other areas of practice. And so when things go bad, the ARDC is going to be looking at the entire relationship. And even if that's not the central focus of the complaint, if there's some ARDC question, do you want to heap that on there as well, that this very vulnerable client felt compelled to accede to your request for a testimonial? I just don't think it serves you well.
And apropos to that, we turn to Hypo 8, where that client not only didn't want to give you a testimonial,
Took the $50 and then did what, Bob?
Can I just ask one question here that Michael has about AVO, that what if there are incorrect things on your AVO site, and the only way that you can correct it is if you claim the profile that all AVO requires you to do that?
Well, isn't that a matter between you and AVO?
Well, isn't that,
How about you
isn't that how AVO...
file a deck action against them? And then
And I think we're going to get into LinkedIn in terms of also if there's endorsements on you, and if they're not correct, are you under an onus to...
This is almost the same question we're going to talk about,
Yeah.
particularly if it's a negative. Go ahead, Bob. I think this
Okay.
is a fascinating
This
area.
is a good one. True story. A former client posted a negative review of a lawyer's capabilities on LinkedIn after a court entered a defense verdict against the former client in the former client's claim for personal injuries resulting from an automobile accident. The lawyer is quite upset by the review and wishes to write a response. Well, first off, what ethical advice would you give to the lawyer, at the outset of that? And, Mark, what do you think?
Okay, I'm going to give you 3 points of ethical advice, but I'm going to preface it with this. One, you will face negative feedback in your career. I don't care if you're a brand new lawyer or a 40 or 50-year practitioner, you know it by now. You will face negative feedback regardless of all the success and outcomes of your client cases, regardless of what type of practice you have, you will face negative feedback. 2, you will be tempted to fire right back from the hip, of course. We've all been there. And not just for negative feedback, but responding to social commentary and so forth, especially in today's age. But there will be more options to come in the future. There'll be more AVOs, there'll be more LinkedIn, there'll be more review sites in the future. They're making money. Money breeds more options. So what do? Well, I think the first and probably the most important is truth will set you free, truth and transparency. So make sure your profile is accurate, and do not attempt to hide past problems of your own. Do not attempt to misinform or misadvise the response to this negative feedback. Be truthful about it. And also, first and foremost, you are never to expose any client confidentialities. Okay, that is important. 2, if you are going to respond...
So let's stay on that point, just to be clear.
Yes.
Client says, rotten, worst lawyer in the world, really jammed me up, didn't let me tell my story in the courtroom, and it really impacted the juror's perception of me. You know the client said, hey, this is what I'm saying, this is a story I'm sticking to, I'm not listening to a darn thing you say, and can't you then say, well, that client I told the client the right stuff, and the client didn't listen to me. That's a violation, right?
Well, you have... My option 3 is do nothing, and sometimes that may be the
There you
best
go.
option. But if you are going to reply, the key words to remember is proportionate and restrained. Okay. Rule 1.6, again, that's priority, not revealing client confidentialities. You cannot do that no matter what. And you may be tempted, and part of your explanation, Bob, is to go down that road because you need to go beyond the public record to clarify to the future readers of your post why they're saying this negative thing about you.
Bring up 1.6.
But here's a tip for you, and I found this helpful when I give advice. People say, well, what do I actually say? That's helpful, Mark. Be proportional, be restrained, but what actually words should I use? Can you give me an example? And I say, well, turn to the pros. Go to websites like TripAdvisor and read some of the responses that hotels write, negative reviews. Wow, it's an art form, right? They have done this for years and years. They're pros at it. And the point that usually comes out, I'd say 9 times out of 10, is that client writing that negative review just wants to be heard, just wants to have their voice heard. And by you just acknowledging that and saying, yes, I hear you what you're saying, and myself or my firm takes great interest in your opinion, et cetera, and we hope we can correct it, or please stop by my office to discuss it further. Short, simple, sweet, and you've pacified that client, and maybe they're going to come back and
Mark,
do better.
we have a question here, though, from Jane that says that are you under an onus to comb the websites and to see if your ratings and other things that are said about you are accurate, whether it's these LinkedIn endorsements or claiming what Avo and other websites are saying about you? What's your affirmative duty to do that?
Yes, I think that goes to the requirement of false information. Once you've claimed that site, you need to go on there and see. Now, different platforms, and this goes to the question at the beginning of the scenario, is what does that platform allow you to do if there is false information? Besides just respond to it with your own words, can you do more? Can you get it removed? What's your steps? With Avo, here's your options. Avo has a little less control. You can either, one, respond to it in the comment below it, or two, you can flag it. What does that mean? Well, you're literally clicking a button next to it that says flag, and then it goes into this dispute process that Avo controls. I've never experienced that and know much about it. Maybe like my panelists do, but that's one thing. LinkedIn gives you a little more options, and I kind of like it. LinkedIn, you can either remove the review completely from your LinkedIn profile by clicking a box, and it's gone, no matter how positive or negative it is. So that gives you the power to remove misinformation or false information right there. It also, of course, allows you to reply to the review. It also, if someone posts a negative review, or a lawyer peer of yours gives you an endorsement that isn't that great or has some misinformation in it, you click a button that says ask for changes, and you send an email to that attorney or that client saying, I appreciate your review, but actually I don't practice in DUI law. I used to 10 years ago, haven't done it for so long. Could you please correct that issue on my website? Okay. So it gives you a little more
But
flexibility.
if the lawyer hasn't claimed the profile,
Right.
there's no affirmative obligation.
That's right.
That's absolutely correct.
Right.
Okay, good. We're on the clock. Let's keep going here.
Can I just add here, 1.6 is up on the screen. Two important points to realize. Read the first paragraph. Your duty of confidentiality is much broader than just privileged information. So you're obliged to keep confidential information you learned in the course of representing a client, even if it later becomes public. Your duty is broader than just privileged information.
Give us an example that's meaningful.
Well, I'm going to actually give you a case to explain how this has turned into a fairly controversial, again, First Amendment issue in just 1 second. But I want to focus on one other thing before I answer Bob's question. If you take a look at paragraph number 5, where you see that you can use client-protected information as to respond to a claim or defense on behalf of the lawyer, but a negative online review is captured by the last clause, or to respond to allegations in any proceeding. Now, you need to be aware of, again, your jurisdiction, because this language has not been adopted the same way in every state. One state has eliminated the word in any proceeding. Another state, New York, has changed allegations to accusations. There are 3 ethics opinions that I've discovered, the most, all within the past 2 years, as you might imagine, because this is a new phenomenon. Pennsylvania, New York, and when the word proceeding isn't included in the rule, accusations or allegations usually come up in the context of a proceeding, and therefore you may not respond to a negative online review. New York actually says, hey, this is no different than something appeared in the newspaper. You just got to suck it up, live with the fact that you're in the profession and some people may not like your work. Pennsylvania has recommended the following as your response, and New York and D.C. both suggested this wasn't a bad response. Quote, a lawyer's duty to keep client confidences has few exceptions, and in an abundance of caution, I do not feel at liberty to respond in a point-by-point fashion in this forum. Suffice it to say that I do not believe that the Post presents a fair and accurate picture of the events, and move on. And so, again, this is in the materials. You can take a look at it. To respond to your question, Bob, there is an interesting Supreme Court of Virginia opinion which holds that a lawyer who's blogging about a completed case, is a criminal lawyer, blogging about a completed case with information that's now public, barred by the Virginia bar rules, but the Virginia Supreme Court just held that there's a First Amendment right, again, under this central Hudson standard, First Amendment right, because a newspaper or a television station could have reported the exact same information. A lawyer should be able to do things in a blog post. Now, that same opinion also said that that was advertising, and the lawyer had to comply with the bar advertising rules. But there's a First Amendment right there, and so query whether, in this context, if the information is public, do you have a First Amendment right to respond to the negative online review with information learned in the course of representation, not privileged? Mark's absolutely right. You never touch the privileged part of it, but are you allowed to deal with public information to respond to a negative online review? In light of this Supreme Court of Virginia opinion, the answer may well be yes, but nothing's arisen in that arena just yet.
Okay, thank you.
Well, let me conclude by the point also is this is not just a former client sending you an email or a snail mail letter complaining in some degree and you replying back in the same mode. This is public. This is on a platform, and it's also just as important, if not more important, that future potential clients are going to see your response as well. So not just the person who complained, but future clients. So it is almost a form of advertising in and of itself.
Okay. Let's talk about a social media platform much in the news nowadays, Twitter. But tweeting, we're tweeting and trolling for clients. So in hypo number 9, you prepare a press release on your recent success as a lawyer. You send tweets to potential clients to alert them about the press releases. What ethical issues, if any, do you see?
So there's a fascinating... we did a little poll before we started, and not many of you tweet, as I recall. That's accurate, right? How many tweet in the room? Yes. Okay. Well, actually, there's probably 10 or 12 in the room. You know, there's a 140-character limitation in Twitter, and the Missouri bar actually issued an opinion that explained that since you're limited to 140 characters and the disclaimers required to comply with the Missouri advertising rules consume more than 140 characters, you may not use Twitter to tweet, so for clients or to advertise. New York Bar and the Florida Bar have also now have guidelines or an opinion out on the topic. Both agree that you're advertising, and therefore you must comply with the advertising rules. The larger question is whether it's also a solicitation, because there are limits, as you know, restrictions on solicitation in the bar rules, again, vary from state to state. And so you need to pay attention to whether or not you're soliciting as well. But you must comply. I think you have to conclude that when you're tweeting, sending something like this out, you are advertising.
Wait a minute. You can't say, great verdict today achieved in the Smith v. Jones case. You know, rah-rah for me, like somebody else we all know does.
I think I need to refer you to Mark for the disciplinary problem here.
Well, there's questions of what applies, and I think John's point is that, yes, the advertising rules do apply to tweets, and just because they're on a certain platform doesn't mean you have an exception.
Okay. All right. Well, let's change it up a little bit and talk about blogs, though, a related thing.
You know, can I just add something before we move on to blogs?
Yes, Judge.
In terms of the 140-character limit for tweets, keep in mind if you're going to go that route, Rule 7.1, even truthful statements can be characterized as misleading and violate the rule. So you can't omit necessary facts that give the tweet as a whole broader meaning. So please keep that in mind.
I think before we go on, we need to talk about LinkedIn here for a second. Well, if you're on LinkedIn, there's actually a dichotomy in the bar opinions on this very topic now.
Why?
Because this is the City Bar of New York says that merely being on LinkedIn doesn't necessarily represent advertising. It goes through, it's a lengthy opinion which I cover in great detail in my paper, but it asks this question: is the primary purpose of you being on LinkedIn pecuniary gain, and then there's 4 other factors that it looks at to decide whether it's advertising. It specifically disagrees with the County Bar of New York that says that being on LinkedIn is lawyer advertising, because why else would you be on the platform except to try to get more clients? But you now have a dichotomy within the same jurisdiction, the city and county of New York, as to whether or not being on LinkedIn is advertising. It's actually a very interesting question. The Florida bar rules say that you are advertising if you're on LinkedIn. But I invite you to read the City Bar of New York opinion at some length, because it gives, in one part of the opinion, again, they're listed in my paper, 10 different reasons why you might be on LinkedIn. You've got family connections, and you want to keep up with them that way as opposed to doing it on some other recommend, however, and this is, Mark raised his hand because he said it was advertising. I would recommend that you comply with the advertising rules if you're on LinkedIn, because it's not worth it to be wrong.
I think the best advice thus far I've been hearing is from Judge Egan, where she says nothing good is going to come of this.
Well, I don't think it's a problem for lawyers to be on it. In fact, there's lots of reasons to be on it. But if your purpose is really to advance your career, comply with the advertising rules.
Okay.
One thing to be careful about that these platforms allow, LinkedIn allows it all the time, Facebook allows it, is for you to connect your account and automatically send a request to everybody at the same time. For example, all your contacts with a push of a button. Do not do this. That is creating a communication with everybody at one time. You need to do it selectively and singularly to each individual person with your own control. So think about it before you do select all and please add all, just to get your contacts up or your friends up or whatever.
Bob, can I raise one other thing?
One other. Okay.
So there's an Illinois bar opinion, 9610, which relates to LinkedIn. It's an older opinion, but it has value here. And it says that merely posting general comments on a bulletin board or a chat room is not considered to be a solicitation, address, office location, and the like. But if you're soliciting, you can get yourself in more trouble. But you should know that there are opinions from Michigan, West Virginia, Utah, and Virginia that take a different view of that, whereas the City of Philadelphia Bar in Florida agree with the Illinois opinion. So again, know your jurisdiction.
All right. Panelists, we're running a little bit behind here, so let's be mindful of the clock. All right, hypothetical number 10. You write a popular legal blog. It has been a great source of work for you in your trial practice. You have an upcoming jury trial, and you write a blog piece describing the allegations of the complaint and the answer and identifying the issues to be tried. Are there any ethical rules there? Are there any ethical violations there? I answered my own question. So I write the legal issue in this case is X, and here's the answers to why the given result should follow. Is there a problem with that? Is that lawyer advertising? Is that solicitation? Does that blog impact the jury pool? Any of those things?
Well, just like
what do you think, Mark?
Lawyers like to always say, maybe. Again, we have
That's what judges think.
You always have to ring that 1.6 bell off the bat, the confidentiality. You cannot release that in a blog or other aspects. But what else can you not do? 3.6 comes into play, trial publicity, especially if it's an ongoing, current, continuing litigation. What can you say? That doesn't mean you have to be completely silent. And that's not what appears to be happening here. These seem to be very simple, factual disseminations to the public here, very informational. So if you look at the enumerated allowances under 3.6b, you can say things to the press or to the public or via a blog in this case. There's nothing wrong with that. In fact, it may be encouraged for the public's know-how.
Can I interrupt and
Please.
just say, if we tweak it a little bit, instead of upcoming trial, ongoing trial?
Yes. Yeah. Same thing.
Even worse.
Yeah.
Even worse.
Yeah.
Then you got Rule 3.5 to worry about.
Yeah. And with extra careful consideration if it's criminal versus civil, too.
All right. Let's beat the LinkedIn drum one more time. Hypothetical number 11.
But before you leave it, there's at least one bar ethics opinion that says that if you're a blogger and you're talking about matters that relate to your practice, consider getting informed consent, which is a defined term under the rules, from your client just to be a safe, thoughtful practitioner. The D.C. Bar opinion from last November, 370, says that you should get informed consent. So be aware of that.
Although Mark's got a very issue-free blog for the Commission on Professionalism that I recommend to everybody.
Thanks for the plug.
Very good. All
One
right.
quick question from the internet here, and from John, probably to John here, is if you're going to be, when you're going back to tweeting, if you select the particular recipients of the tweet, does that negate the advertising rule regarding global?
But let's just change the question a little bit differently. If you're in a chat room, for example, you're interacting generally on social media, which I think takes us actually to the next question.
Okay.
And in fact, why don't you read it, and then they'll
Sure.
pick up with that question.
You monitor LinkedIn regular. Well, wait. You still on the questions?
No, let's go to number.
Yeah,
let's go to number 11,
Yeah.
and then
All right.
I'll respond to that question.
Okay. And this is the last we're talking about LinkedIn today. You monitor LinkedIn regularly. A person you exchange business card with once shoots you a message describing a set of facts without mentioning any names and asks whether you think there is a viable claim. You respond, yes.
Right.
Any ethical concerns there?
Right. So to respond to the questioner's question, there's a whole body of ethic opinions, and again, they're discussed in the paper, that make the distinction between a targeted request made just to you that no one else sees, a request made to you that others see that then you respond to by taking it out of that public forum and responding directly to that individual, and whether or not there's a solicitation under one situation or the other. And I'm afraid that my answer has to be to the questioner, look at your jurisdiction, find out whether there are any ethics opinions that deal with this question. If they're not, read the paper which discusses the various permutations of, there's a New York bar opinion that goes through 5 different scenarios as to how to deal with those very facts. On the merits of this particular hypothetical, I'll just start off and then punt it to Lynn and Mark to pick up with the very simple question of Model Rule 1.7. Anybody remember what that deals with, 1.7? Shout it out. Conflicts. Person's asking you a question. Who is that person? How do you know that person isn't adverse to one of your firm's clients? Or represents a particular point of view from an issue conflict standpoint that could be concerning to your clients?
Or you create an attorney-client relationship?
Or a prospective attorney-client relationship. Absolutely. Taking you into a different rule, the 1.18 problem of gaining information and arguably being accused of establishing an attorney-client relationship or learning something that bars you from representing one of your clients in a matter because of something you learned in this give and take. And I'll flip it to you guys to pick it up from there.
Or that person is already represented by counsel, but they're surfing the internet to find better answers, quote unquote, or other answers too.
Okay.
Regarding LinkedIn here, just somebody pointed out, John, to an earlier comment that you made regarding why would a person be on LinkedIn unless it was for gaining clients, but what about in-house counsel who might be using LinkedIn to find a job?
Yeah, I mean, that's an example of that New York City bar opinion that said there are reasons to be on LinkedIn that don't relate to advertising.
Can I ask a question of Mark? I mean, we got all these permutations. Where does the ARDC doesn't have the resources to go chasing this issue? None of the states do right now. I mean, are we making a bigger fuss about things than we ought to, or what's your take on that?
Oh, I think it's all about how are you in your role as an attorney, both in your own practice, but also representing the profession, because we are professionals. How are you going to proactively establish your own rules?
Yes.
What are you going to follow? And that's why the ethics rule has been changed. 1.1 has been changed and modified to include technology, and that's an important transition that we are recognizing. Yes, the landscape is changing, the legal profession is changing, the society is changing. We have to roll with it, and rules usually play catch-up later on, but we have to follow the flexibility as they progress.
Okay.
And I think we can expect to see a greater focus from the ARDC on some of these issues. I think they're going to be catching up, too.
In the area of blogging, chat room responses, LinkedIn responses to questions, one distinction to keep in mind from the ethics opinions is if it If you're answering as if you're giving a seminar like this, a CLE answer, that's okay. The bar opinions all say that's fine. It's when you step beyond that and start personalizing the discussion with that particular person that you may find yourself in an advertising solicitation arena.
And I think a lot of this enhances the obligation of the lawyers in the bar to engage in the professionalism that we have an expectation of the profession doing.
Well, just look at the preamble to the Illinois rules. A lawyer should strive to attain the highest level of skill, to improve the law in the legal profession, and to exemplify the legal profession's ideals of public service.
There we go.
Pretty lofty.
Let's talk about crowdfunding. New issue. Hypothetical 12. A lawyer solicits contributions on a crowdfunding site to pay the legal fees in an action the lawyer plans to bring on behalf of an indigent client against a governmental entity. The funds would be paid directly to the lawyer. Wow. Has that one got ethical problems associated with it?
Who knows about, in the room, who knows about crowdfunding? Anybody? Anybody engaged in crowdfunding in the room?
About it.
Everyone, anybody engaged in it? For legal, to gain legal fees to pay for a matter? No one.
No.
So this is a very, I'll start off for the panel.
This is a real case?
Oh, absolutely. Absolutely. And the front page of the New York Times about a month ago was on crowdfunding for legal fees, the business section. It's very real. City of Philadelphia bar opinion is the basis for these facts. But think about it for a second. And the City of Philadelphia bar opinion facts were a lawyer who's going to represent an indigent party against a governmental entity to solve or cure a particular social ill of some kind, knowing that there would be crowdfunders out there who would be willing to fund something like this and wanted permission from the bar to do it. Well, how much money are you going to raise? And where's the money going to be put? Is it going to go into your operating account? Into a trust account? Can you resign the representation? Are you going to stick with it until the very end of the matter? Or can you pull out? Or suppose the client isn't happy with your representation at some point and fires you. Do you get to keep all the money? Suppose the matter involves fee shifting, so that if you prevail, you can recover your attorney's fees. And your fee agreement says that if that occurs, you get to keep not just the crowd-funded money, but also the attorney's fees awarded by the court after you prevail. This is an area that's fraught with risk. The opinions are described in, the one opinion that's out there is described in detail in the paper. The ultimate conclusion is use a third-party trust to receive the funds. You got to be worried about a non-refundable retainer, which could turn into an excessive fee. You got to be worried about a 1.5 issue, a reasonable fee issue in this arena, and the way to, and of course, another issue, Mark and Lynn, you're now putting out information to the crowdfunders to let them know what it is they're going to be funding and what are some of the issues there.
Don't you also have fee sharing among lawyers as an issue?
And what about the issue of a lawyer being paid a fee by a non-client?
Lawyer being, and you've got that, you've got division of fee questions. The bar opinion essentially overcomes all of the topics except the excessive fee, non-refundable retainer issue, and because of those, the 1.6 confidentiality issue, how much you disclose to let the crowdfunders know what's going on. They assume that the lawyer could carefully draft the crowdfunding request so that nothing confidential would be disclosed. But when they got to all these issues associated with lawyers staying on, lawyer being fired, non-refundable retainer, money going into operating account, said this is not sounding real good. Put the money in trust, remove the fees as you earn them. You can only withdraw when you've actually earned all those fees as opposed to doing it earlier and keeping the money. Now, the bar opinions don't refer to what happens if there's a residual in that trust account. But Mark, I'm very interested in your reaction to crowdfunding.
Oh, I think this is, has a lot of future potential. It kind of reminds me of what letter C are you designating the money towards? In the past, we see, especially lately, the ACLU. Are you donating to a cause? Now this is very different. You're donating to the case, the actual case in and of itself. And the case, crowdfunding succeeds because there's a good sell. You have to have a good sell, and that's when you develop your crowdfunding page with all the details and the marketing to the people who are going to donate $5, $100, $1,000, and what have you. So I'm even talking precursors before you get to that. How do you delineate, how do you regulate that? Is it regulatable? Should it be? Who becomes the client, really? in
Mark,
that
your
aspect?
answer is implying that you think that there's a way that crowdfunding could be used legally
Well,
and ethically.
I think there's going to be these models. For instance, take it to a similar degree like what Avo's been doing with generating referrals, and that's a simple way to put it. But are they taking a chunk of the fee in a referral context, and is that allowable? And how is that going to continue to evolve as different types of referral systems online especially are developed?
We have a question from the floor. Yes, sir.
How is this not champerty or maintenance?
Well, you know, most of the champerty and maintenance case law is really, this is in the litigation funding context, third-party funding context.
Or crowdfunding?
Yeah, well, but in the litigation funding context, there's now quite a number of decisions that have basically said that champerty and maintenance really aren't going to apply in third-party funding situations. I don't think that would really raise a bar, and I could do it offline, give you the citations.
But in typical litigation funding, they're not actually funding the litigation. They're providing funds to a litigant in the situation.
That's right.
Not
That's
actually
right.
funding.
And the moral of the story, I think, is here, to try to keep us moving, is that if you're going to engage in crowdfunding for a case, you need to carefully look at that issue and the issues that the panel has identified for us already, especially on fee sharing, division of fees, client's consent, all that stuff is on the table. Let's move on to hypothetical number 13, text messages. And this one should be pretty quick for us. A new personal injury client's communications with friends. What ethical issues are lurking there? My answer, none. No. I know that's not right, but John, or at least you're going to tell me it's not right, John.
Well, I mean, really it's competence, and the issue is preservation. The new D.C. bar opinion from November of last year highlights the point that you not only in representing a client need to make sure that if texts are relevant to a claim or defense, if there's a duty to preserve, that your client preserves, but then you also have an obligation, obviously, to ferret out the information from any opponent and check for text messages that might be relevant to a claim or defense. And then, of course, you also have to worry about privilege waiver. Who has access to the text sender's mobile device? My wife knows my password. I don't use text messaging for anything that's privileged. I keep my password from my wife. My children are older now. But who among you know that your password for any of your mobile device that may contain privileged information is known by a family member? Text messaging is fraught with risk. I tell individual clients in particular, I mean, we're just not going to, just don't do it.
How about new Federal Rule 37E?
So this is a rule that deals with the loss of electronically stored information went into effect December 1st of 2015, and it provides for when a duty to preserve attaches, you must take reasonable steps to preserve the information. If you fail to take reasonable steps to preserve the information and the information cannot be restored, then you face corrective measures, no more than is necessary to cure the prejudice. And if intentional acts occur to destroy the text messages, you could be facing an adverse inference instruction. The materials discuss several cases, but it's basically a preservation issue, and most corporate systems don't capture text messages, but a lot of individuals who may be witnesses in a case text. So you just need to be mindful as a lawyer up front, understand the texting habits of people that matter in your case, whether they're your client or the opponent, and then figure out what you need to do to preserve on your end and what you need to do to make sure that your opponent preserves so that you don't end up fighting over the preservation issues.
And just remember, 37 is only applicable when the duty to preserve arises. And in Illinois, duty to preserve evidence is governed by the Supreme Court decision in Boyd.
And if you're going to get your clients...
Boyd versus Travelers Insurance Company.
Yeah. And if you're going to get your client's authorization to do something and the authorization comes to you in a text, take a screenshot of it, save it to the file, if that's how you're going to, handle that situation, so that you have a recordation of the authorization you were given.
And you can look to my blog on how to do a screenshot.
We're asking, is there any difference between email and text security?
The email security is a whole... We're going to do an ethics program on that.
But as far as waiver goes, John mentioned just people who have your password to your phone. But for all you loyal Mac users out there who use iMessage, you know that that message coming into your phone is also probably going to every single computer you have too. So if that computer at home is sitting opened and you're getting some text message to iMessenger, they're also popping up on your home computer where the home babysitter is looking at them too, or any other device with iMessenger, all simultaneously.
Okay.
Privilege is all waived.
Let's go to number 14, which is another iteration of this, and I'm going to really kind of combine it maybe with 16 to move this along. We've got about 9 minutes left in our program. 14, Company A is in a business dispute with Company B in federal court. At the meet and confer session, counsel for Company B tells counsel for A that all text message of Company A's employees will be sought in discovery. A so advises counsel for Company B. John, what's your take on that in terms of the duties of the corporation and of the lawyer?
Well, so the ethics rule is 1.13 that describes the duties of a lawyer to an organization. And there's a lot of language in there that gives lawyers lots of room for deciding that you don't need to do very much. But here the lawyer, again, falls into that arena of, are the text messages going to be relevant to a claim or defense? And if they are, the fact that the corporate server doesn't capture them doesn't mean that you don't have to capture each of those phones that the employees use. I've just completed tenure as a special master in a case where all of the cell phones of the employees, a big antitrust lawsuit, where all of the cell phones of the employees of the plaintiff were forensically examined by order of the court, because in depositions they all testified that they texted for business reasons and they weren't preserved. And so it's an area where if you believe that your in-house counsel is not acting in the best interest of the corporation, your basic duty is to go up the ladder. You've got to go up the ladder. That's essentially what the rule says, but there's a lot of weaselly language in there that gives lawyers ways out, because there's a business relationship aspect here as well, who's paying your bills. But ultimately, you've got to care about the client and not the individual in-house counsel you're working with. And so if you believe there's jeopardy, you have to act.
Okay, in that same vein, number 16, in that same vein, I'll come back to 15, because it's related in concept. You get an individual client now who wants you to handle litigation against her employer. The client gives you her work email addresses and telephone number because she doesn't want to be bothered at home. So that means that you're going to be communicating with this new client, an individual, at her new job through that company's server and all that about this case against the employer. Are there any issues there about privilege?
Well, almost all employers, even sort of small shops, have internet usage policies that forbid personal use and discloses that the employee's conduct on work computers are going to be monitored. And so the risk of waiver is great. There's been a development since the written materials went out. There's part of the handout is discoverability of this sort of information. In the last 60 days, the 2nd District Appellate Court in Illinois came out with the case Carlson versus Jerosek, Jerousek, 2016, ILAP 2nd, 151248. Personal injury lawsuit. The plaintiff was alleging physical as well as cognitive deficits, claimed that his work, his ability to function at work had been compromised, and the attorney sought very broad-based access to all of his personal and work computers, all of his social media accounts, and login information. The trial court ultimately ordered that all of the computers, personal and work, be turned over for forensic imaging. The appellate court reversed, saying that is not consistent with the amended Supreme Court Rules 201B4, which deals with ESI, and 201C3 that covers the topic of proportionality. Burden and expense always has to be considered. So on the discoverability side of this issue, take a look at that case. Yes, 2016, Ill App 2nd, 151248, Carlson versus Jurasek. It's a very instructive read. But sort of on the ethical side, too, think about it. There was a recent situation where a pretty sophisticated lawyer in Cook County working for an employer during work hours used his work computer to access his personal email account and his personal Facebook page, where he posted some unflattering remarks about former First Lady Michelle Obama. It was his personal Facebook page, after all. Well, he got fired, and not surprisingly, that employer had a policy about using the internet while at work. So if we take it into the client context, I don't think it matters that it is a personal situation, a personal computer. If there are computers that others have access to, you're going to open up the possibility of waiving any privilege. So I just think you have to be very careful, and it gets back to the very first rule, 1.1, your basic level of competence. You have to understand who has access, what access is possible with all of these electronic devices, so that you know where to pull back your communications with the client.
Okay, so we
Let me
have,
just,
at the moment, we have
10 seconds, Bob, just to note Model Rule 4.4. If you receive privileged information that you know was inadvertently produced, you have a duty to notify the sender. So keep that in mind if you represent that employer that's obtained the information.
There you go. So in a rapid, we got 3 minutes left. We have I want to cover the last really two, because we covered the third, hypos, posting of a videotape deposition online and safeguarding the property of a client that's in the cloud. Mark, let's start in reverse order. Tell us about the videotape, because that's a big one. And nowadays there's all sorts of stuff on videotape, and can I put it on my website?
Yeah,
for the world to see.
The quick answer is Rule 3.6, trial publicity. It could be interpreted as advertising if you're putting it on YouTube and adding your website link to it, for instance, especially if you're just cutting a portion of the dep and not the whole dep. That's certainly a problem, and it was in this Texas case. This is a real-life situation. And it could be misleading and so forth. So in this case, it was removed, and then the court, they put it back up again with a disclaimer saying, well, this was only part of the video shown to resolve the matter.
And be careful about protective orders when it comes to that one. You could easily be violating the protective order.
And don't do something that's embarrassing, 4.4a problem, to another person.
John, would you tell us a little bit about the cloud?
Well, the virtual law firm, there is a recent Illinois opinion out. It's not referenced specifically in the materials, but it's Illinois 16/06, decided October of 2016. But essentially, as you can imagine, if you're going to use a cloud storage provider for confidential information, think about what you have to do. Make sure that that provider isn't going to violate your obligations to protect the confidentiality of your client. My paper contains a reference to one of the opinions in this field. There are about a dozen now. That is a checklist of things you have to pay attention to. Please read it.
And Your Honor, at 4:29, we always give you the judiciary the last word.
Great seeing everybody. Court's adjourned.
Thank you. So sorry we couldn't take more questions. Thank you so very much for being here. We'll see you next year for our 11th annual. Have a good evening.
Yes, and thank you for attending today's program, The Ethics of social media inside and out of the courtroom. Please be sure to fill out and submit the evaluation form that is found on your desks there or by clicking on the evaluation tab online. Certificates of attendance will be emailed within the next week. On behalf of all of us at Clifford Law Offices, we thank you for attending. See you next year.
Okay, don't forget...